Hi everyone, it's Matt Hudson here from SV Partners. I'm here with Omar from QBCC, and we're here to talk about the new project trust accounts. Now I see we've got quite a few people joining, so I'm just going to give it another 20 seconds or so. But effectively, what we're going to be talking about today is, I guess, new reforms that are coming out, in particular next year for a lot of business owners in the construction space here in Queensland. These two new trust account regimes that effectively you need to be applying, called project trust accounts and retention trust accounts. So we're going to delve into that in a bit of detail today. We're going to go through some of the framework of it, some of the accounting and practical things that people need to be aware of. And then I guess the final part of it really is we're going to look at a case study example of a company called Bob's Builders Proprietary Limited. And we're just going to have a look at some of the challenges and that might be faced by it if it was to be appointed, if a liquidator was to be appointed over that entity. So I think we've got quite a few people now on. So before I get started, please feel free at any stage, ask questions, share, do whatever you need to do on the post. As much feedback as possible would be great for the two of us. Please feel free. If you think we're not explaining something well enough, or you just want some clarity on some issues, please just ask a question. But effectively, what this is SV Partners LinkedIn Live. We ran numerous of these last year, and we'll continue to try to roll out as many of these as we possibly can throughout the course of the year. So please feel free to sign up to any of the SV Partners newsletters or events, parts of our website. There's so much information on there, and please also follow my page on LinkedIn. So I'm joined today by Omar Ameer from QBCC. You're the Director of Financial Compliance with the QBCC. Welcome aboard.
Thank you very much, Matt. It's great to be here.
Yeah. So if you maybe just for the audience, just say a little one or two things about yourself.
For sure. So my part of QBCC, as the name position title suggests, deals with all things to do with the financial regulation of the building industry in Queensland. So we look after minimum financial requirements. We look after what happens to licensees when they're involved in a construction company that goes insolvent. And we also, as we're here today, we deal with project trust accounts and the regulation of those as well. So fairly broad portfolio. I was with an environmental regulator in Queensland before I came to QBCC a couple of years ago, and way back prior to that, I did actually do insolvency and dispute resolution litigation.
Yeah, I saw that at Gators.
Yeah, that's right. Yeah. So I know a little bit. I can still remember some key things about insolvency law, but I'm still in that a little knowledge is a dangerous thing kind of phase.
Oh, it's forever changing. So basically, I'm an associate director here at SV Partners. We do insolvency restructuring. And I was just saying to Omar before we came on that we're noticing substantial amount of construction companies going through insolvency external administration at the moment. We're trying our best to help these people and creditors to get their money and stuff like that. But I think seeing what potentially is coming moving forward, and then knowing that these project trust accounts come in, that's why I thought it's such a coup to be able to get Omar on today to talk about what will be coming, just to give some insights. So let's start with, I guess, the framework. So as I said at the start, we've got two trust accounts. So maybe you just explain a little bit about what's required there. Yeah,
for sure. So, and that's right, Matt. There's two types of trust accounts. We've got the project trust accounts and the retention trust accounts. And this framework kind of really builds on, or it's an evolution from the previous project bank account framework. And some folks who may have been involved with construction contracts for government over the last few years may be familiar with this project bank account framework. So now we've evolved and developed that and basically got it fit for purpose to roll out across the private sector as well as state government. So with our project trust accounts, certain contracts for construction work in Queensland are going to meet some eligibility criteria, and they will be required, or the head contractor for those contracts will be required to open a project trust account. So it's a per project basis. So you could very well have multiple project trust accounts if you're a builder doing any amount of work. And all of your, and I'm sure we'll get to this in more detail, but all of your funds for that particular project have to be managed through that one project trust account.
So that's all like your progress claims and your debts.
That's exactly right. So that's your progress payments from your client, from the developer, go into the project trust account, and you're dispersing that out to your subcontractors.
And no longer So in the old day, the money used to go into your personal bank or your company's bank account, and then you could effectively disperse that with whoever creditor was pushing hardest, basically.
That's exactly right. So we sort of think of it as a bit of a quarantining of those payments to a particular specific project. That's right.
Yeah. And sorry, the other trust account? Yeah.
And so then we've got our retention trust account. So if you're working on one of these jobs that requires a project trust account, at the moment, if you're the head contractor and you withhold a cash retention from one of your subcontractors, then that cash retention has to go into the retention trust account. And again, instead of sitting in your trading account, which would have been the case prior to this, that sits in the retention trust account. You only need one retention trust account. So unlike a project trust account where you might have multiple, you can get away with just one retention trust account. But all of your cash retentions from however many project trust projects you've got on the go goes and sits in that retention trust account, and they sit there until they're either dispersed back to whoever you withheld the retention from, or until you yourself as the builder are entitled to draw on that retention to fix defective work or whatever. In certain circumstances, principals, so developers may require a retention trust account, and we'll talk about the rollout later. You'll eventually find some subcontractors are going to need those as well.
And so when I was looking online, so I decided to have a quick look this morning. There's currently 202 project trust accounts and 90. What are we thinking for next year? We understand that. Let's start with first question. When are they roughly rolling out next year? And then secondly, what sort of numbers and are QBCC ready and able to go with that?
For sure. So at the moment, we've got full coverage across the state government sector in terms of jobs involving state government principals. In the private sector at the moment, we're at private sector contracts that are worth $10 million or more, and there's exemptions and all of the rest of it we don't necessarily need to go into now. But broadly speaking, private sector and local government construction contracts worth over $10 million. When we get to April next year, so April 2023, is when that $10 million cap drops down to $3 million, and we start to kind of expand it a bit more across the private sector. And then October 2023 is when we hit full implementation, and that's when we're at any private sector or local government, state government contract where the contract value is $1 million or more is going to require one of these project trust accounts. So you can imagine that $1 million doesn't get you a huge amount of building work at the moment, let alone in 18 months. So look, in terms of coverage, it is still a little bit of it's more art than science at the moment, trying to work that out. I would expect probably around about a couple of thousand projects per year, I would think, requiring project trust accounts, and then a number of retention trust accounts to sort of support that. So we're certainly talking potentially quite a significant volume, and anybody who's building anything very much outside of particularly certain residential contracts, is probably going to find that they've got need to have one of these project trust accounts.
So pretty well October 2023, that's when the absolute bulk of these trust accounts are going to come into effect. So
that's right.
Everyone's got a little bit of time to prepare, get ready for it. And once we get to section 3 of what we're going to sort of talk about today, I think that's when we'll start highlighting some of the issues for people that they need to be considering now, because October 2023 is going to come around so quick.
For sure, it'll fly past.
But something I noticed when I was looking up those numbers, QBCC have actually put out a really handy register that you can go onto on their online website, where it tells you all of the different names, easily searchable and whatnot. So, if you're an advisor wanting to become more familiar with it and try to understand what other people are doing, please go and check that out. I found it very easy to look at. I started actually looking at some of the details of some of the other ones that have already come up, and I thought it was easier to search than the ASIC one.
Okay, I'll pass it on to the web team. That's good feedback. Thanks, Matt.
And it's also free, so that was also good. The other, the other thing I think people need to realise is that it is quite limited in what these trust accounts or who the financial institutions actually can be. So from what I could see on the website, there's only been 6 approved financial institutions in the country. Basically, your big 4, HSBC and Macquarie, were the 6. What are we expecting moving forward? Is it by October? Is it going to be rolled out to a broader array? Or
I would expect so. So there's a couple of other financial institutions that we're in discussions with at the moment. I mean, it is very much a commercial decision for any individual bank as to whether they see the market opportunity. I mean, the requirements that QBCC places on them is not particularly onerous, but I certainly expect that by October, we'll see a number more. And by interesting contrast, solicitors' trust accounts, similarly, you have to have an approved institution. There's 11 banks, I think, approved for those. So I expect we'll be there or thereabouts. I would think by October next year.
Well, that's good to know, because I think most people will think, I can just go to my local banker and set up, but there are actually pretty strict requirements, and but it's not codified by the Act, which was something I thought was good, that it still gives a discretion to the Commissioner so that you can have these discussions with different banks. So that was something I was having a look at. So if you can just explain to us then, so we've talked about that you've got to set up these trust accounts. You've got 20 business days to do so, from effectively the date of the contract. There's probably some exceptions in that, but let's say that you've had to set this thing up. But who is it benefiting? Who are the actual beneficiaries of these trusts?
Absolutely. So the whole project trust account framework is really designed to provide protections for subcontractors. So there is a definition in the Act, and it's as convoluted as some of these can be in an Act, but there's a defined class of subcontractor beneficiaries, and those are going to be subcontractors who are engaged directly by the builder, by the head contractor, who are doing what the Act defines as protected work, which is a pretty broad, everything you would consider to be typical building and construction work and then some. So fairly broad coverage. But interesting to note, it won't include suppliers typically, for example. So your trade suppliers, your Bunnings, your steel suppliers, all of those sorts of suppliers who simply supply an off-the-shelf product, they're not going to get the protection of this. If they're doing some work, if there's prefabrication, if there's some of those elements involved, and then they're supplying a prefabricated potentially. But basically, it's those subcontractor beneficiaries who are doing what you would typically think of as building or construction or related sort of work.
Yeah, because I noticed it didn't apply to subbies of subbies.
No, that's exactly right.
It just stops at the subbies level, and it doesn't cover suppliers or sub-subs.
Yeah, that's exactly right.
And I did also note that there are some specific rules around related entities and stuff, but we don't have to go into that. And I understand that you've got to give notice as well. So you set it up 20 business days, and then you need to be obviously advising the subbies where your money is being held and stuff like that.
That's exactly, and QBCC too as well. So that register you mentioned, that's populated through the notifications that we receive. And part of what we do with the banks is just to cross-check that we have actually been informed of all of the accounts that they've had, so that register should be pretty reliable.
So moving on to, I guess, more of the administration of these trust accounts, and then thinking about, I guess, the practical consequences for accountants who might be tuning in, or any lawyers or business owners for that matter. So I guess let's talking about financial reporting to start with. How is this going to be different from what they're currently doing? And maybe you can just talk to that.
For sure. So probably two key things that immediately spring to mind, Matt. So the first, just in terms of the administration of the account, and as we mentioned, that quarantining idea for those project trust accounts. If you're paying a subby who you've engaged on job A, that payment has to come out of project trust account A. And what that can do is, if you've got subbies working across multiple jobs for you, I know a lot of builders at the moment will get all of the payment claims from that subby in at the end of the month, gross them all up, and then just make one lump sum payment. So that won't be possible now, because you have to have, if they've got 5 projects for you, 5 different project trust accounts, you've got to get payments out of those individual trusts. So that's going to be a bit of a thing for the accounts payable folks, I think, to work out how to work with that. And then around the record keeping,
I can just stop you on that, because I think there's actually a really interesting point there, that something we've experienced lately is we get appointed to a company in liquidation, and the head contractor looks at us, we're the subby involved. They go, well, look, you couldn't complete this one project. You did complete the other, but we're going to commingle our set-off rights against the two. So effectively what that means is you might be owed money on the project you completed, but we say that there's a liquidated damage claim for, say, double the amount you're owed on the second project. So they'll just offset the two, and then you don't get anything. So I'm imagining here these trust accounts will, I guess, almost stop that.
Look, I won't express a view on the ins and outs of that, but certainly it is going to give people a bit more pause for thought, I think, as to how they then manage those various relationships where they've got creditors who are owed money or potentially have offset claims themselves.
So going on about the reporting stuff with it, especially I think practically speaking, thinking about accounting software and how a business owner is actually going to keep records of this stuff. I think I read somewhere in there that you got to do monthly reconciliations, and the retentions trust must be audited once a year and reported. I think the project trust account doesn't necessarily need to, but QBCC at any time can direct that it occur.
Look, so lots in that, Matt, lots of interesting stuff in that. So on the record keeping, and that's going to be a big change, and we've certainly found that this is something I think that the industry and the accounting profession is probably going to need to spend a bit of time getting their heads around. So the Act requires individual trust account ledgers for each of the trust accounts that a trustee has, and that which means that you'll have your business ledger where you're keeping all of the transactions for your business, but separate to that, trustees are going to need to have a trust account ledger, and then potentially multiple, in the same way again that a solicitor will have their law practice ledger and then their trust account ledger. And that, I think we're going to see that that's going to potentially be challenging, because you've got some of the bigger players already have 10, 12, 15 trust accounts on the go. And it's where people are, I guess, finding some difficulties at the moment is that they're using their business ledger. They're trying to do these monthly reconciliations. They're trying to do these, exercises out of their business ledger for their trust account, and that's quite challenging because the software isn't set up to do that. Once I think people kind of get their heads around moving to individual trust account ledgers, some of those monthly bank reconciliations, monthly trial balances will actually become a lot easier. Then you're going to have the logistical challenge of finding that software that can cope with sort of several ledgers on the go at once.
I think, like, especially for if there's any accountants listening at the moment, thinking about it from a business owner's perspective, if you're in that sort of middle or lower market in construction, you're not really going to have to go out and buy a whole nother bit of software or anything. So I guess people are going to be hoping that your Xeros, your MyObs, QuickBooks, those types of guys are going to be able to come up with some type of software solution for this. But are you hearing any rumors about?
I know there are some. We do hear that there are some of those third-party providers are aware that this is an issue/opportunity. And they'll make their own decisions about how they can support it. I know that there are some industry associations that are working with accounting firms for ways that they can support their members with this. So there's definitely stuff happening. And look, we know that it's an issue. We know that it's a challenge. And as QBCC, we're talking with the Department of Energy and Public Works, who owns the legislation, and they're doing some work as well just to understand other ways that we can make this easier or support folks to comply a bit more easily.
Yeah, because I noticed that there's now a couple of organisations that are going to start rolling out some training sessions and that, or for their members and things like that. So I thought that was a good initiative and things that are really going to need to happen, I think.
Yeah, absolutely. And it is worth bearing in mind that, we are still in the relatively early days. I mean, it's been around since March last year, but it's only since January we've started to get that coverage into the private sector. And I think, and we understand as the regulator, it'll take time for the sector to kind of work things through and to catch up with where they need to be.
Talked a bit about financial reporting and that. I think probably the number one issue for everyone's going to be the Mfr reports, so the minimum financial requirement reports. Actually, we might stop there and ask if you can maybe just quickly explain what those are and,
of course.
And the importance that QBCC places on that.
Yeah, absolutely. So a condition of holding a contractor's license, so builder's license, in Queensland is that your business meet the minimum financial requirements at all times. And the Mfr report is the vehicle that we use to get the financial information from our licensees that shows that they meet those financial requirements. We tend to only call for those where we have either where someone's looking to change their license, maximum revenue, and we need to have some assurance, or where we've identified a problem and we're conducting an audit, or we're asking to show cause around licensing action. And we just want the Mfr report, because it's prepared by an accountant who has some level of independence from the licensee, we have a little bit more assurance that the figures that we're getting are something that we can rely on to assess the position. So that's the Mfr report. And it does have, it has its own regulation. It sits off the QBCC Act, and it does have its own quirks and complexities that accountants kind of need to be across when they're working in this space. And I think where we're going to go is how some of this is going to interact with trust accounts.
Yeah, well, especially as like under that Mfr, you've got to meet the net tangible asset requirements and that. And when I look at a lot of balance sheets and that for builders and subbies and that, they always record in their balance sheet or in the asset section, all their retentions, all their debtors and stuff like that. They generally rely upon that to meet their net tangible asset requirements. But I think what's happening here in these new trusts is that rather than the priority existing under the head contract, so the head contractor effectively in the old way would get paid from the developer, and then they would then be free to disperse the funds as they desire effectively. Whereas now the priority exists with the subby. If you have a look at any of the section 51s under this new act, it talks a lot about the fact that subbies have priority over the head contractor. So we're effectively now going to get into this issue of head contractors may not actually be able to record these trust accounts as an asset necessarily. There might be like technical views on how you can do that, but what happens if there's not enough funds in there or whatever. So I think there's going to be some MFR reporting issues. So maybe if you could speak to that.
Yeah, well, look, and we this is something that internally we're looking at, and I think we've got a meeting coming up with a trustee just to kind of go through a particular case example with them at the moment. And because the money that is held in those trust accounts is, by virtue of the Act, beneficially owned in certain circumstances by other people.
Yeah.
And so I think there is a question about whether that can be counted as an asset, and then what do you do with the offsetting liability, because you've still got the liability, but you may lose the asset. And look, we're going to look at ways that we can understand the implications of this and look to come to an understanding that, because what we don't necessarily want this to cause downstream dramas. Yeah. This is supposed to be a protective piece of legislation, not one that causes unforeseen circumstances. So we're certainly going to be looking at how we can kind of reconcile these two and not have any sort of unforeseen issues cropping up because of how the two pieces interact.
Yeah, and I think that goes back to the very nature of what a trust is. You hold the funds on trust for others.
Yeah.
You can be a beneficiary of that trust. But the way that legislation works is that you might be a beneficiary, but you're subordinate to the subbies, effectively.
Yeah, I think definitely. I mean, the legislation is certainly in terms of if there's not enough in the trust account to pay everybody plus yourself as a trustee, then definitely the subbies will get first cut. But certainly, yes, the trustees are going to be beneficially entitled to some of that money in their own right.
Yeah. Absolutely. And so the relevant act is called the Building Industry Fairness Security of Payment Act. And the section I'm referencing there is section 20 capital B. And so that's the one that talks about this idea of the priority. And I think that's a massive change to what it has been in the past. And what we'll do shortly is go through and explain how that interacts in the insolvency world, because I think that's a big difference. If you might also just talk a little bit about what is allowed to be paid out.
Yeah, absolutely. And again, this is very much in the frame of that quarantining and making. So with the project trust accounts, the only money that is allowed to go into those project trust accounts are the progress payments from the principal to the head contractor. Certain other exceptions if you need to correct mistakes when you've mistakenly withdrawn money. But all of the payments from the principal and only the payments from the principal go into the project trust account. And then the only payments out of the project trust account are to pay those subcontractor beneficiaries, for the trustee, the head contractor, to effectively pay themselves what they're entitled to for their overhead and margin and supplies and other costs, and they can move that money into their trading account. And then if they're withholding a cash retention, the head contractor can move the value of that retention from the project trust account effectively into their retention trust account. But certainly no other payments are allowed out of that project trust account unless it's to pay the subcontractor beneficiary or to remit the money back to the head contractor. Retention trust accounts are in a sense even more restrictive. The only payments that can go into a retention trust account are payments that are withheld under a contract where there's a project trust account, and the only payments out of that retention trust account are to either return the money to whoever it was retained from, or to use it to pay the head contractor effectively for the cost of rectifying defective or incomplete work where they've got the contractual entitlement. And I think, Matt, that is the really big shift, because it's head contractors who hold a lot of cash retentions at the moment, that sits in their trading account, and that's effectively that's a working capital source for them. And as long as there is money in there to pay out, practical completion or whenever, they can use that money as they like. And the big change, and I think the thing that I think people really hopefully will use this time to get through to October to get to grips with, is that all of those cash retentions are now quarantined and can't be touched except in those limited circumstances. And I think in terms of the effect on the construction industry in Queensland, that is going to be the one that we would like to see people most engaging with early, especially where they've gone and have a big exposure to these project trust contracts and may need to think about how is this going to affect me.
Yeah, because under Section 56 of this Act, it actually talks about that the collateral is actually has a priority security interest. So what I found under there was that taking that example, old school retention monies for say from a subby just sit in the general bank account used for working capital, whereas here those funds are held on trust for the subby and they have a superior priority security interest over everything. The way it talks because it makes reference back to the PPSA, Personal Property Securities Act, which is Commonwealth legislation. But effectively, that's what it's doing here, and I thought that was quite interesting. And what I've noticed, for instance, I've got a couple of trading voluntary administrations where there's a couple of builders that we're trying to do some completions and project work and that, and you've got a couple of subbies involved or a lot of subbies involved, and it's very hard to explain to them why they can't just get their retention monies back. They might have completed all the work and that, but at the moment, the way the law works is that they're really just an unsecured creditor. They have no trust rights. They've got no security rights. So I think this will fundamentally change that. But we'll come back to that in a bit more soon. But I think that was probably the main stuff from an accounting perspective in that. I haven't noticed any questions yet from anyone in the audience. So please, that's why I keep looking down. I'm just watching to see if there's any comments pop up. So please feel free, if we're going too fast or you just want any more explanation about some of the intricacies here, please let us know. But in the meantime, I might jump onto Bob's Builders, favorite cartoon growing up. But no, this is a fictitious name, Bob's Builders Proprietary Limited. And let's say it's gone into external administration. All of these things have already come in, but it's got some projects still on the go. QBCC might have extended a temporary license to the administrator to finish the work. Let's maybe, if we can just maybe talk about some of the issues that we were talking about before we actually came on today. Some things that I noticed in the legislation is that, let's say, the administrator has to administer these trusts. What I can see under the Act is Section 51C says that there's no right to fees. So I think one of the big changes here is that if the head contractor was to, spend all this money setting up, all these reporting requirements and doing monthly reconciliations and, buying all this new software and stuff, I thought it was interesting that they can't actually on charge those as administrative fees or costs or anything like that. That's right?
Yeah, that's exactly right. They have to effectively, the trustee in a solvent situation is absorbing those costs as part of their business rather than charging it to the trust account and thereby reducing the amount that's available for the subcontractor beneficiaries.
And it talks about, because what we see a lot is in order for head contractors and principals to offset debt so that they don't have to pay a liquidator, they always add all these administrative charges and stuff. But effectively what this would be doing is it specifically says costs and fees. So they wouldn't be able to do any costs and fees. But in what I can sort of see here, what also might be an issue is that the administrator liquidator facilitating that trust account also may not be allowed to be paid any money. And although this really only talks about the specific head contractor or developer or whatever, there's actually another provision, 51E, that actually talks about agency. So if a liquidator would generally be seen as the agent for the entity, so would then that also prevent them from being paid?
And look, I think there's going to be some really fascinating questions once we do see some of these, particularly these larger trustee companies, go into insolvency. I mean, if you think about it in terms of the framework is there to ensure that subcontractors get paid in full and on time. And so from that logic, it makes sense that the trustee can't remove fees from the trust account, thereby leaving insufficient money in there for the beneficiaries. And fascinating if you're interested in this sort of thing, because you've got this contractual overlay over there. So you've got these subcontractors who have a contractual right for payment. So the legislation is set up so that they can't receive less than what they're entitled to be paid because the trustee has decided to charge fees in there. So that interesting dynamic then sitting next to or on top of a liquidator's right to charge fees. Now, whether the liquidator can then go and take those fees from other the fees that they incur in administering the trust account from other funds held by the head contractor that aren't held in trust is, again, leave that to the liquidators and their solicitors. But those provisions are there just to protect, I think, the integrity of the amounts in those trust accounts. And ensure that builders as much as possible, subcontractors as much as possible, get their contractual entitlements.
And I can sort of see how that applies from the perspective of if the administration of that trust account is quick and easy. So if you're thinking that the company's not going to continue trading or whatever, and you just want to disperse the funds out, you do a quick adjudication in that. I could maybe understand it, but my concern here will be that you're going to get liquidator appointed to XYZ Proprietary Limited. They've got thousands of subbies, millions in these trust accounts, but yet they can't be paid to administer any of it or do anything. So I can see there being some teething issues in that, and then trying to work out whether or not the Corps Act priorities and that will trump the priorities under here is another issue. Those who may not be familiar, Constitution basically says that Commonwealth law trumps state. So there might be some things in there, but there's always exceptions to the rule. So who knows? I'll leave that for QCs and judges. But the thing that I noticed in there was that if a liquidator was to decide, well, look, this isn't worth it. If I'm not going to get paid, why would I facilitate all this process and stuff? Because liquidators are liable for pretty well everything. I think there's a couple of issues under there. One is that they might just disclaim under the Corporations Act. So disclaimer under the Corporations Act effectively removes their liability from them having to do this. Whether or not that actually applies here, I don't know. We'd need to think about that more. We've got a bit of time. But then the second issue here is that liquidator might just say, well, disclaimers don't apply. So, but I don't really need to do anything. I just won't do anything because I don't, under the Corporations Act, effectively, if you don't get paid, then you don't have to really do a lot of things. That's probably a very simplistic way of saying that, but I'll just keep that for now. But something I noticed under the Act was that there's all these civil liability provisions, which you might be able to talk to around executive officers and stuff. And the executive officer definition to me is read as if it potentially could also cover a liquidator or administrator. And if that's the case, then potentially they could be personally liable if they don't meet these very strict requirements and they're not facilitating that.
And look, just quickly back on the question of liquidators' fees, and again, it'll be something for the QCs, no doubt, but it may be the case that the legislation would certainly stop them from charging, or certainly stops the trustee from charging fees to the beneficiaries and removing that from the trust account. Query whether it would stop a liquidator reimbursing themselves for their costs and expenses from other funds held by that. So I think that'll be an interesting one to.
How often do they have other funds
to come across? Well, there is that. That is a fair point. Matt. But then
I am putting you on the spot.
Oh no. This is part of the fun. But I do. But on executive officer liability, yes, there's provisions in the Building Industry Fairness Act that say that in certain circumstances, executive officers will, and in fact, will commit an offence as though they were the company. And that's not atypical in a lot of regulatory statutes these days. That directors and so forth. We get to pierce the corporate veil, and the director can't just let the company take the fall and walk away when they are the ones who have caused that. So yes, again, we'll have to look and see the extent to which liquidators fall within those. But I will say, and we've got a copy of the regulatory guide on the desk in front of us, and when we're considering whether we do take enforcement action, we do look at things like culpability, things like state of mind. We're not here to put liquidators in jail or to drag them before the courts for reasonable things that they've done in the course of their engagement. So what comfort that may give the profession, they can take for themselves. But certainly we will use those provisions where there is a level of culpability on the part of the controlling mind of a corporation. Query whether liquidators are ever likely to be in that position.
Yeah, because I think as a profession we need to think about are there alternative options here around potentially trying to have receivers appointed over the top and stuff like that. I couldn't find any specific powers under the Act for that. All I could really see is that the Commissioner and the trustee have a right to apply to the Supreme Court in Queensland, and they can apply for directions.
Yeah.
Whether or not that's broad enough to also apply for a receivership appointment, I couldn't see that in the time I had to prepare. But I think they're the types of things that we probably need to think about as maybe a workaround or stuff like that. The other thing I thought, some other interesting points, 51A of the Act talks about the fact that the trustee can't use any of these trust funds for its own debts. Which very much goes in line with what we're finding in the insolvency profession now with, the Amarind case in the High Court talking, if you've got trust funds here and company funds here, you can't use trust funds for company debts.
Yes.
It really can only go towards trust creditors. I pause to say trust creditors is a fiction. You can't technically have trust creditors, but that's just an easy way to describe it. But so that was probably one key thing. And then Section 51 talks about if there's a trust shortfall, then the trustee is effectively personally liable for the shortfall. So that those trustee company funds here can actually be used to pay the beneficiaries, which is quite different to how it is in equity. So in equity, as it currently stands, is that wouldn't apply. You couldn't do that. So
which makes sense. It is a change, but it makes sense when you think of the fact that this trustee-beneficiary relationship has a contractual relationship overlaid over the top of it. And I think that's a really interesting feature of this framework, because you have these two usually separately quite distinct frameworks, but sitting right over the top. And so those sorts of provisions, I think, make logical sense when you think that, well, what you're asking the trustee to do is really in reaching into their own bank account to pay these beneficiaries is simply to pay their contractual liability out of if they've allowed the trust account to run down and have insufficient funds to pay their contractual debts, which also happen to be beneficial entitlements, to reach into a different fund of money that they have to ensure that they're paying those debts that they owe.
The interesting thing, though, that what comes to mind there is that what happens if you've got, so in the trust account, you've got a shortfall, but it's a shortfall that effectively you can pay out all the subbies, but you can only pay, say, half of the debts owed to you. And then you're effectively then going to have to take money from your corporate account, put it into the trust account to cover that shortfall, even though it's effectively your own money. And the reason why I'm saying this is that you've got trust creditors. I hate saying that phrase, but you've got trust creditors of the company, but also the company's own creditors outside of that trust. So I think you're going to find that there's going to be a lot of litigation around that triangle, to be honest, which I look forward to reading about. I think that was probably the main stuff from that I had to talk about from an insolvency perspective. I think the takeaways from me on this insolvency side is more around the fees, the way that we're going to have to try to almost audit in a way some of this stuff, because if you've got, I talked before about adjudicating, so say you've got 1,000 subbies, there's a shortfall in the trust account, the liquidator is then effectively going to have to go through an audit and work out, how we're going to pay out the funds to everyone and who has priority and all that. I understand that effectively all those subbies would, but then you'd have to pro rata it out to them all, and so I think there's a lot of work in there and a lot of learning for liquidators and external administrators, and then working out how they're going to get paid to do that as well. I think that's probably the main things. And then from a business owner perspective, I can see it as, well, I need to really start thinking about MFRs, so minimum financial reporting for next year, in particular, thinking about that, all my retentions and debtors might be taken out of my balance sheet. So how am I going to meet these requirements? That the ATO is running really hard at the moment on debt collection, going to get a lot worse next year. I need to be forward planning on that side. I need to be talking to my trusted advisor, so my accountant or my lawyer, about setting up my accounting software in the right way. Unfortunately, might have to get some training done for your staff and that on it. I might have to pay for more staff to deal with it. So,
and it was the April and the October phases for next year, and it was a decision by government rather than one of the QBCC. But they took a decision to actually those are pushed out. That would have happened by the end of this year ordinarily. And I think that a lot of the reasoning behind pushing those dates out into next year was to give folks time and recognising COVID's been a thing. Accounting processes and software needs a while to kind of catch up. And so definitely, I would certainly encourage folks to use this extra opportunity now to get everything in place, especially those who know they're going to have quite a bit of exposure in the project trust account space.
Yeah, and there's heaps of experts out there, heaps of lawyers and accountants that no doubt are well across this stuff, and that you should be reaching out to and talk to them. If you want to be put in contact with any of them, please reach out. I'm happy to help you. I think they're probably the key things from my perspective. I think it's a really big win for subbies from what I can see. People might have a different view on that, but I can certainly see how subbies are going to benefit from this. It's probably the head contractor in the middle there that's probably going to, be the most impacted. You need to be fully across this stuff, which I thought was, a very important message for everyone out there. So
yeah, absolutely. And look, a quick plug just to help folks get ready. As you mentioned, our website's very kind of you because it's gone through a major refresh in the last couple of weeks, Matt. But we do have a ton of resources up on that website. So we've got trustee guides, we've got beneficiary guides, we've got online tools to help work out whether a trust account is required. We run webinars, online webinars.
And that tool was actually quite handy as well, because I played around with it to see. I tried different options of whether or not you needed it now or soon or never and stuff like that. So jump on and you can just press all these different buttons and like some sentences there I didn't really understand, but it had a little question mark. Click on that and explains what that meant and stuff. So
fantastic. No, definitely encourage folks to get up to speed using all of the resources we've got.
Yeah. I've just got a quick message from Paul Farmer saying that he thought that you've done very well and it's very insightful. So thank you, Paul. I appreciate that. If anyone's got any questions, we're about to finish. We normally only go for about 40 minutes on this, but I thought, we've got a lot to get through and this is a very difficult area. So trying to get through it. But please, if you've got any questions or comments, please put them through and I'll certainly give them to Omar if I think we need to.
Sure.
Please jump onto their website. I found it very easy. So hopefully everyone else will too. Thank you very much for your time.
Absolute pleasure.
Really appreciate it.
Thank you for having me, Matt. It's been fun.
Yeah, thank you. And thank you everyone else for coming along today. I know it's been a little bit of time since I've been on LinkedIn. It goes to show how very busy it is at the moment. But hopefully I can roll out some more of this stuff. And you never know, next year when all this is really rolling out, we might be able to get Omar back again and talk about, more the practical side of what we should be doing and stuff like that. So, thanks everyone. Really appreciate it. And we'll end the show now. So thank you. Cheers.